to order. And Ann, if you can just show that 6 of the commissioners are here. Commissioner Mills is not present. He has recused himself. His wife is on the Park and Shade Committee. And with that, turn it over to you, Mr. Walton.
We're here today on the Park and Shade Tree Committee's motion to dismiss. We laid out some parameters ahead of time, and specifically that each party would be limited to a presentation of 30 minutes. We're going to go forward just like we would in a court. Mr. Mandalis's motion, it's his motion. He will go first. He will then have a response, and if he has any time left over, he can present a rebuttal. That's how we'll proceed. The only issue here that's before the commissioners today is ultimately whether or not the appeal was timely filed. This is not, we do not talk about the substance. We're not here about the substance of the underlying merits of the appeal. If in fact, if you did find that the appeal was timely filed or could go forward, what would then happen is we would set another date for a hearing at a later time.
May I?
Another question? Gary Glass, 105 Country Club Drive.
I understood that you sold the piece of property to Steve or to Mr. Bieber, and I question why you're not recusing yourself from this process.
Question. It's false.
You did not sell the property.
I did not sell the property.
Okay, thank you. Okay, that's what I heard.
I'm sure. Thank you. Sorry, Glenn, didn't mean to interrupt.
Not a problem. Thank you, Mayor and Commissioners, City Manager, Mr. Walton. How are you? It's always interesting to see you in that chair because I'm so used to having that chair. But in this instance, I am representing the Parks and Shade Tree Commission. I have, just for the record, so the record's clear, I've not had any correspondence or communication with the Board of Commissioners on this matter other than my written submissions that I submitted to Mr. Walton, who presumably have been provided to all of you. So in this instance, you should not see me in the role of city solicitor. Your counsel is Mr. Walton, and he, as he's been advising you, he'll advise you on this. I'm here today on behalf of the Park and Shade Tree Commission, and it's the Park and Shade Tree Commission's motion to dismiss the current appeal that's dated June 10, 2019. You'll be happy to know I will not take nearly the 30 minutes that's been allotted to me. So the appeal was dated June 10, 2019. The decision that the appellants are seeking to appeal was issued on November 23rd, 2015.
Can I interrupt you? I don't think that's correct. The reply memorandum is dated June the 10th. The appeal was earlier.
My apologies, you're right about that. And in any event, it was a 2019 appeal that relates back to a 2015, November 23rd, 2015 decision of the Parks and Shade Tree Commission. And just to give you some perspective of that period of time, which is approximately 1,300 days or 3.5 years, since that time, 4 Christmases have passed. We have all gone through 4 New Year's celebrations. There was a U.S. presidential election. We watched the Winter Olympics. We lost George H.W. Bush. We lost Stephen Hawking. We lost Mary Tyler Moore. And this one I never thought would happen. Peyton Manning retired from the NFL. President Obama visited Cuba. No president did that since 1928. Bill Cosby was put on trial, and Apple became the first American public company to reach $1 trillion in value. All that stuff happened since the time the Parks and Shade Tree Commission made their decision and this appeal was filed. The point is, a lot of time has passed, and frankly, too much time has passed for an appeal now to be brought before the commissioners. So it should be dismissed for any or all of the following 3 reasons. All of these 3 reasons relate to the untimeliness of the appeal. First, the delay in filing the case is unreasonable by any common standard, and I'm going to talk about those standards in a moment. Second, the appeal is barred by the legal concept of latches, so as a matter of law, it shouldn't be able to go forward. And third, the appeal ordinance, in this instance, gives the Board of Commissioners the absolute discretion to simply choose to not hear the appeal. Now, that's an option that typically is not very appetizing because as a Board of Commissioners, you typically want everybody to have their day in court. But in this instance, I think it's appropriate due to the severity of the delay in time. So first, the appellant's delay is unreasonable. So the courts have said when an administrative agency has not adopted a specific time limit for an appeal, the standard of reasonableness should be applied. So in our case today, we have a code section, section 25320, that sets up an appeal process for appeals from the Parks and Shade Tree Commission. But in that section, 25320, it says that any person can appeal from any ruling or order of the Parks and Shade Tree Commission, but it doesn't give a time for filing the appeal. So part of the question today is, how are you to determine in what time that appeal should be filed? And what the courts have said is where there's not a time allotted in the statute, the standard of reasonableness should be applied. And again, the decision that appellants are seeking to appeal in this case is over 3 years old. So you have to ask yourself whether that's reasonable or unreasonable. And I submit that an over 3-year period of time is unreasonable. Many of our sections in our code talk about filing an appeal within 10 days, within 30 days, but you won't find it in our code and probably any other municipality's code that a 3-year time period is a reasonable time period to file an appeal from any decision made by the municipal government. The procedural history of this matter also demonstrates that the delay was unreasonable and contextually disjointed. The appellants in 2015, on the day the hearing occurred before the Parks and Shade Tree Commission, the appellants paid the $13,000 mitigation fee that's at issue today. So in some ways you would say they acquiesce, they take issue with the term acquiesce in their papers, but they acquiesce to the decision by paying that fee the very day that it was rendered. Then in 2017, they sought to modify that decision, and the Parks and Shade Tree Commission did modify it. Then they got a certificate of occupancy about a year ago. It's unreasonable to think that you can accept a decision, ask for the decision to be modified, then get a certificate of occupancy because you adhered or acquiesced to the decision, and then come back and say, now that I've got a certificate of occupancy, I want to undo the decision that happened 3.5 years ago. It's just completely unreasonable. And if you apply the standard of reasonableness, you'll agree. Also important, I think, to this analysis is the fact that under the statute, anyone can appeal a decision of the Parks and Shade Tree Commission, not just an aggrieved party. So anybody can. So how could you ever have closure on an issue that went before the Parks and Shade Tree Commission if anybody, for any reason, could appeal it at any time? You got to apply some standard, and I'm suggesting the standard here is reasonableness, and 3.5 years just is beyond reasonable. Second, the appeal is barred by the legal doctrine of laches, and here's how the courts have described laches. They say, although there is no hard and fast rule as to what constitutes laches, it is generally defined as an unreasonable delay by the plaintiff in bringing suit after the plaintiff learned of an infringement of his rights, thereby resulting in material prejudice to the defendant. Therefore, laches generally requires the establishment of 3 things. First, knowledge by the claimant. Second, unreasonable delay in bringing the claim. And third, resulting prejudice to the defendant. So there's basically 3 prongs in the analysis. So as of those prongs in this case, first prong being knowledge by the claimant, nobody contests that the claimant was aware of the Park and Shade Tree Commission and the way its proceedings happened. Everything was noticed. So the claimant, the appellant in this case, had knowledge. The second prong is unreasonable delay in bringing the claim. I've already described why I think that it was unreasonable to wait 3.5 years. And the third prong is a resulting prejudice. In this instance, both Building and Licensing Department and interested parties have been prejudiced by the appellant's delay. First, Building and Licensing proceeded to issue a certificate of occupancy based upon the notion that the appellant in this case complied with everything they needed to comply with, including the decision of the Parks and Shade Tree Commission. So if now the decision is overturned, Building and Licensing issued a certificate of occupancy sort of in error because they did it in reliance upon all the boxes being checked. Now we're trying to uncheck one of the boxes. Additionally, parties in interest in the outcome of these proceedings would be prejudiced because they appeared before the Parks and Shade Tree Commission, members of the public, and they are entitled to some form of closure. If their voices were heard and a decision was made, but now they can all be overturned 3.5 years later, that prejudiced those people who went to the hearing and got an outcome and should be able to rely upon that outcome. So because all 3 prongs of the laches analysis are satisfied, this appeal is also barred by that legal doctrine of laches. So third, review by the commissioners is discretionary and should be declined. So as I said earlier, this is an interesting statute in that it gives you the absolute discretion to say for one reason or another, this is just an appeal that we choose not to hear. The statute says the city commissioners shall have the right to review the conduct, acts, and decisions of the Parks and Shade Tree Commission. Any person may appeal from any ruling or order of the Parks and Shade Tree Commission to the city commissioners who may hear the matter and make the final decision. So you may hear it, or you may choose to not hear it. The code affords the commissioners that discretion. In this case, and as I said earlier, it's kind of an unappealing or unappetizing provision in some ways because we in municipal government are typically inclined to give people their day in court. But here, for a lot of reasons, this is, I think, part of the reason that the discretionary element is set up in the statute. Because there is a point in time where you need to say, it's just not equitable. It's not fair to everybody else to allow an appeal to come 3.5 years later, and we're just going to choose not to hear this one. It's just fundamentally unfair to the citizens and property owners of the city of Rehoboth Beach to allow the appeal because they need closure just like everyone needs closure in land use matters. So for all of those reasons, on behalf of the Parks and Shade Tree Commission, we do respectfully request that the commissioners dismiss the appeal, and thank you for being attentive.
Do any of the commissioners have any questions for Mr. Mandalis at this time?
How many fines have been, not fines, but how many homeowners
fees
and
in
at
lieu.
what, and how much have these homeowners paid towards mitigation over the past 3.5 years? And all the things that you mentioned happened in 3.5 years? How many people actually, other homeowners actually paid a mitigation fee, and how much did they pay?
So the Parks and Shade Tree Commission meets once a month, and they generally meet, I can think of a few occasions where they didn't have applications and didn't meet. And it's becoming a little more common than it was before for homeowners to request fees in lieu of mitigation. The tree ordinance, as you all know, can be kind of difficult to comply with sometimes because every tree that comes down needs to be mitigated. And by mitigation, that means you have to plant replacement caliper of tree. And some of the properties as they're developed, there's just not room to plant those additional trees. So it's become pretty common for fees in lieu of mitigation to be requested. And the Parks and Shade Tree Commission do authorize those fees in lieu of mitigation routinely, I would say. I mean, I wouldn't say, I bet it's less than a dozen that have done it in the last, well, there's probably been a dozen to 15 homeowners that have asked for a fee in lieu of mitigation since the appellants had their hearing. And I can't remember a time that a fee was not authorized. I remember a time when a fee was set at 0, but there have been fees paid. I will say that I think the appellants, and I don't recall the caliper numbers that the appellants were dealing with versus some of the other homeowners, but I will say that the appellants, I think their fee was on the higher end of the spectrum.
But I'm sorry, I know this is a fact that it would be almost impossible to ask you to have, but maybe it's something somebody knows. I just kind of want to, I'm trying to understand the scope of how much has been paid. Do you know how much?
I don't know if
Just
if-
roughly the amount of fees.
is the arborist
in
here?
lieu of mitigation?
So when the fee gets paid, it goes into a specific tree fund. So there
Right.
is a fund that we could find the number.
Curious.
I would guess since we've had a Parks and Shade Tree Commission, and this is a pure guess, and just based upon sitting in that chair and listening to the Parks and Shade Tree Commission, I would guess that people have paid probably into that fee between $20,000 and $30,000 since we've had a Parks and Shade Tree Commission, which has been 8 to 10 years now, maybe even more than that. More than that, I think. Yeah,
Thank you.
but again, I could be way off on those numbers. Thanks.
Thanks.
Mr. Mandelis, have there been other appeals to decisions made by the Park and Shade Tree Commission? And do you know if there is like an average amount of time from the decision until those appeals were filed?
So there was an appeal about a year ago by, in fact, Mr. Walton represented you all at that one too. Do you recall when that appeal took place? But that appeal was from a fee in lieu of mitigation, but the fee in lieu of mitigation was was an ancillary issue. What happened there was a person came before the Parks and Shade Tree Commission. The Parks and Shade Tree Commission authorized the removal of a large maple tree. A disgruntled homeowner then appealed that decision. So it wasn't the actual person who came before the Parks and Shade Tree Commission appealing, and they appealed it rather quickly because their concern is that tree was going to come down. So that's the only appeal from the Parks and Shade Tree Commission that's come before this body that I can recall.
Okay, thank you.
$14 minutes, Mr. Maddox.
Thank you.
Good afternoon, everyone. I'm Sandy Bieber, and I'm here with my wife, Linda Rosenzweig. And like all things we do in life, we're going to share our presentation with you today. The essence of our appeal, including our motion to dismiss, is a very simple principle. It's whether the citizens of the city of Rehoboth Beach can rely upon explicit wording in the city code. The tree code is flawed. City solicitors just said that. I think virtually everyone in this room knows that. The question is that it is administered, and certainly was with respect to us, in matters where the tree code was administered not with what it says and not with what it doesn't say. Our appeal raises very important issues with respect to the tree code. Sound policy argues that cases should be heard by administrative bodies like yourself whenever possible, absent the running of the statute of limitations or a clear-cut showing of laches. Neither, as we will explain to you today, has occurred here. You should hear our appeal on its merits. A word about our appeal. It's a complicated area. I'm trying to boil it down into a very succinct set of points. The tree code, contrary to what the city solicitor has just said wrongfully, does not require mitigation for every tree removed. It requires mitigation with respect to two categories of trees. The city decided that we had to plant, and addressing Commissioner Schlosser, your question in part, and Commissioner Sheffer, your question in part, that we had to plant 90 trees on our property, 90 trees on our property. They totally misread the law. They miscalculated how you determine mitigation. Mitigation, in our view, could have been achieved on our property, and therefore the imposing of a fee in lieu of mitigation was inconsistent with the tree code. Let me explain that. The law, if properly applied, as we see it, would have required far fewer trees to be planted than Building and Licensing, the City Arborist, and Park and Shade Tree Commission said we were to plant. We weren't permitted to show that we could achieve mitigation on our property. Our legal arguments were ignored. If we could have showed that with the proper reading of the law, we could have achieved mitigation by planting on the property, you never get to the provision that authorizes the Park and Shade Tree Commission to impose a fee in lieu of mitigation. In fact, a fee in lieu of mitigation is only to be imposed when the applicant, meaning us, demonstrates to the Park and Shade Tree Commission that there is an absence of viability of achieving mitigation on our property. We weren't given that opportunity.
I hate to interrupt you, but I need to object. We're talking about the appeal here.
No. I need to
the
frame this.
motion-
Excuse me, I didn't
I'm
interrupt
gonna-
you, so
I'm
you
gonna-
don't interrupt me.
I talked about why we're here for the
I'm
motion
going
to dismiss.
to overrule the objection. You can continue.
I'm sorry?
I overruled the
Oh,
objection.
thank you. All right, at the risk of being a little bit like I don't know what you call it, here's a copy of the appeal section. And do you want to, should I give this to you and you distribute it the right way? Since the clock is ticking, I'll keep going. But when you get it, you will see it's 2 sentences long. And as you can see in the provision, there is no time period specified for appeals of Park and Shade Tree Commission rulings or orders, unlike almost all other city code appeal provisions dealing with appeals to the city commissioners. When a statute is written with regard and is silent with regard to a time period, one must read the statute as it is written. There is no time period. You don't read it as you might imagine it could be written. The fact that many other appeals provisions in the city code have time periods in which appeals to the commissioners does not require that does not require the commissioners to read a time period into this provision. What it says is that in all those other provisions, the commissioners, in all those other situations, the commissioners decided a time period was appropriate. This does not have a time period. I would also point out that in 2014, when there was a very well-developed proposal from the Planning Commission to revise the tree code, and there was not only a total redrafting of the code, but very helpful policy discussion accompanying commentary, the appeal section was not touched. The appeal section stayed as it was. Mr. Mandela says in questions that you all have asked him, well, how often does this occur and how many fees have been due? If there have only been $20,000 or $30,000 worth of fees in lieu of mitigation, we paid $13,000 of it. So that tells you a little bit about the unjust nature of our situation. In the course of building our home, we experienced numerous hurdles, delays, and interruptions in dealing with the city. We filed our building permit in May of 2015, and we were only able to complete construction and get our certificate of occupancy. Actually, it was dated in April of 2018, but we didn't actually know it existed until May 2018. Given the experience that we had had, and some members on this Board of Commissioners are personally experienced with what we went through, we believe that we should file an appeal of the Park and Shade Tree Commission decision, first rendered in 2015, when we could effectively argue both the law and the facts to establish the appropriateness of our appeal and why the actions taken by the Park and Shade Tree Commission were wrong. Because we could have argued all the law. We could have said, here's what the law of mitigation, this is how it's supposed to operate. This is how many trees that we're supposed to be planting. But then we would still, given our experience, we think we would have still been told, but we don't know if you're going to get all those trees on your property. We felt that the easiest way and the right way to do it was to pay the fee, go forward with trying to get our building permit, which, by the way, we did not get till the end of March 2016, and then implement our building plan, implement then our planting plan, and demonstrate that when we had all the facts, that when you take those facts and the law together, you would see that the mitigation determination was wrong, that we could achieve mitigation on our property, and that a fee in lieu of mitigation was not necessary at all. It was inappropriate. Under those circumstances, we felt that filing within 1 year of our issuance of our certificate of occupancy was reasonable and understandable given all that the particular facts and circumstances of our case.
I'm Linda Rosenzweig. I'm going to address the issue of latches that Mr. Mandelis is arguing. Latches is, he speaks to the fact that latches is an amorphous, loose doctrine that is used. We totally disagree with that. In 2017, the United States Supreme Court recognized that the doctrine of equitable latches is to be used as a gap when the legislature has not provided a fixed time limitation, which is exactly the situation that we have here. And what are the elements? The elements are, as Mr. Mandel has properly said, that the plaintiff had knowledge of his claim. Second, that there was an unreasonable delay in pursuing the claim. And third, and most importantly, all courts focus on the fact of whether or not there was prejudice to the defendant. In this case, it would be to the city. The Supreme Court said in 1969 that for the defense of laches, respondents have to demonstrate an evidence of legitimate prejudice. And that doesn't mean saying that someone may not have had the opportunity to do something. There has to actually be concrete prejudice to the party. So for example, I did find a case this morning, and I apologize for that because I am now under a doctor's care for both Lyme and I've had a terrible, terrible infection. But a case that was decided by the Fourth Circuit on an issue that is sort of similar to this case. The case, excuse me, the case is called Tommy Davis versus Cape Fear. I have one copy that I'm certainly happy to give Mr. Walton.
Can you just read me the citation so I can look it up?
Yes, of course. The case is, it's docket number 142132. I got it as a slip decision off of Google this morning. It's a case that involved the North Carolina Public Utility Company that was assessing impact fees for the provision of water to homeowners and developers. And there was a developer who was trying to develop a property and he was assessed a fee. He opposed it. He tried to object to it. He had appealed it, but since it was holding up the development of his project, he paid it under protest. Thereafter, he filed an appeal. And the city said, well, we think that the statute of limitations here has been passed, even though there was no statute of limitations. There should have been reasonableness. There was no reasonableness. That was rejected. They said, then what about the argument of laches? We think that we were prejudiced. And this is what the court said. The court said, the defendants do not contend that they undertook any expenditures that would have not been otherwise necessary, or that their legal position had been negatively impacted by the passage of time. And since there was neither present in those cases, the argument of laches had to be dismissed. And I would argue the same situation here. There is no prejudice to the city. All the city did in this case was issue the certificate of occupancy to us. If the commissioners were to revisit the decision of the Park and Tree Commission, obviously it would not be that we would be revoking, but we're simply asking for a modification of that decision. It would not, that too would not be prejudicing the city. There has to be something more concrete than, as Mr. Mandalis is arguing, some sort of closure for the public and the city. That is not enough to rise to the level of asserting and being able to prove laches as a defense. Thank you.
As Mr. Mandalis said, this appeal provision is discretionary with respect to the commissioners. You have, as the statute says, the right to review the conduct, acts, and decisions of the Park and Shade Tree Commission, and you may hear an appeal and make a final decision. The city solicitor has said on the record in our 2015 case that ambiguity exists within the tree code. It's not entirely clear. A landowner arguably should be able to read the tree code and know what they can do with their land, end quote. We agree. And we implore the commissioners to consider our case to bring clarity and transparency to the tree removal and mitigation provisions of the tree code. If the commissioners aren't happy with the appeal provision in the tree code, you should change it. But the law is what it is. The words say what they say. And for citizens to look at the tree code and say that they can appeal a decision or a ruling or a decision of the Park and Shade Tree Commission, they should be able to do that. In our case, we think that we have filed an appeal within a reasonable period of time, given all that has occurred with us, the very complexity of determining not just mitigation, but the fee in lieu of mitigation, and how that all impacts the viability or the absence of viability of planting trees on one's own property. So we urge the commissioners to accept our appeal as timely filed and to recognize the serious nature of the issues that are presented in our appeal and agree to address them. And Linda and I are happy to answer any of your questions or any of the points that Mr. Mandelis raised that you would like us to address.
Does anyone have any questions? Any of the commissioners have any questions?
Well, the only question I have at the moment is, my understanding of this process today is that we're making a determination whether this has been filed in a reasonable amount of time.
That's correct.
And so, although I have read everything about this particular case, we're in a situation of just making that decision, correct?
Making the timeliness decision, that's correct,
Okay.
because that's what the motion
Well, I
is.
just want to be on the record to make sure that that is what we're here for.
That's indeed. We're not going to hear the merits of the case today. As I said at the beginning, we would,
Right.
if the commission decides they want to hear the appeal or finds that it's timely filed, we'll set another date and we'll have a hearing on that.
Yeah, but you just said something different to me. You said
Sorry.
you made it, if they decide, if the commissioners decide they want to hear the appeal, that
The
not-
timeliness of the appeal, so there was two, and if I was unclear, the timeliness appeal is what's at stake here. There's also a second component which Mr. Mandelis raised, is whether there's a discretionary nature under the statute itself. The commission may hear the appeal, so that's why I said it in both ways.
Okay, thank you.
Does anyone have any
Can I-
additional questions?
I
The
guess, can I ask a question? Mr. Bieber, can I ask why you're filing the appeal now, like at this date versus a year ago or 2 years or a year from now? Can I ask, is that okay to ask that
Sure.
question? So, thank you.
We filed the appeal in April of this year. We got, the certificate of occupancy was dated in April last year. The way we have been told, and we understood the entire process of mitigation to take place, was that in 2015, we basically were told we were not going to get a permit to remove any tree unless we paid the fee in lieu of mitigation. And our arguments about the 90 trees and all that stuff was just, it didn't matter. In 2017, we wanted to substantially enhance our tree plan. We hadn't really started doing it yet. We couldn't even demonstrate the viability of planting trees on our own property yet. But we now that we had the house in place, you know, the framing and so on, we now saw how much more we could do. And we went to the city arborist and said, can we add to the, and she said, no, you have to go back to the Park and Shade Tree Commission because you're under a very strict order with the specifics to your plan. So even if you're changing, if you're enhancing it by 50%, it does not matter. So our view was confirmed by that 2017 hearing that we weren't in a position to appeal because we needed to prove the facts as well as argue the law. We thought we had it all nailed after the 2017 hearing, and lo and behold, in March of 2018, our builder and our landscaper are told to stop everything they're doing, and that in fact, we may have to totally reconfigure our driveways and remove a lot of our trees that were just being planted because our plans were wrong and the sidewalks that we had proposed to have there and the curb cuts and the sidewalk cuts were wrong as a matter of law. We had to make an appointment with building and licensing. We had to come in. We had to present that, in fact, our plans were correct, that, in fact, our curb cuts were correct. In fact, the mayor happened to be sitting in on that meeting. We then had to go back and start all over again. That just told us, again, another instance where we didn't know if our tree plan was going to be fully implemented to even show what we could show until we got our certificate of occupancy. Because when you get a certificate of occupancy, when you're under a mitigation plan, the city arborist must come in as part of granting your certificate of occupancy to say, yeah, you've done what you said you'd do, or more so. But you at least meet what you've done. So when our 2017 plan, which was substantially an enhancement over the 2015 plan, was still now the baseline. It was that was what we had to meet at that point. In fact, over the summer, we even did more so. But we just decided that after all of that, we needed to collect all of our data. We needed to actually count our trees. We had to measure the calipers. We had to go through everything again to be absolutely certain that we had achieved what we thought we could achieve. And that is why, under all those circumstances and more, we felt that filing in less than a year after we got our certificate of occupancy was a reasonable thing for us to do.
Is that not perhaps the reason why there is no time limit on the appeal procedure? I mean, there's got to be a reason why. This is one of the only provisions that has no time limit on appeal, because it is an ongoing oversight process with the city. And if not, I'm not sure why it's not an easy fix to simply amend the law. But one presumes some reasonableness in why it was drafted the way it was.
If I could, question. When you came in with your new enhanced plan in 2017, was there anything said about the money that you'd paid in 15, like, okay, we'll rethink that money and
No,
so
we
start
were
the
told the
process?
specific issue to present to the Park and Shade Tree Commission was solely the modification of the tree plan itself. In other words, the number of trees, the type of trees, et cetera. That we were not reopening all the rest of the order, but merely, if you will, the inventory of trees.
Okay, so it wasn't.
Because we went to the city arborist. We thought that this was an easy thing. We thought we'd go to the city arborist and say, you know what our baseline is. We're going to do this much more. Is that okay? And she said, no, I really can't do that. That I need to have you go back to Park and Shade Tree Commission. So we had to have our landscape architect and our landscaper prepare submission, and go to the Park and Shade Tree Commission to present the plan. And there were interested persons there, and there were issues raised with respect to the plan, and those were answered. And then we continued on from there.
But there was nothing ever said that, okay, now you've got a new plan, let's go back to the drawing board on the mitigation fee.
No, because from our point, nothing was raised by the Park and Shade Tree Commission, to be certain. But from our perspective, we still couldn't prove. See, this was a little bit of a different thing, Mayor. In the cases that we've looked at that are appeals of Park and Shade Tree Commission, or even in matters that are before the Park and Shade Tree Commission that deal with fees in lieu, they really have to do with 1 or 2 or 3 trees and whether you're going to pay $3,000 or $4,000 or $2,000 or $100 or whatever it is, and it's that simple. That wasn't our issue. Our issue wasn't the extraordinary amount of money we had to pay. It was that there should have never been a fee in lieu of mitigation imposed in the first place. And we couldn't prove that with certainty, and also take our view of how the law is supposed to be applied until everything was done.
Well, I mean, given that, I'm sorry, if I can just finish. Given that, was it your plan back in 15 to eventually appeal this after you got your C of O?
Honestly, we didn't think about it in 2015. We had already waited a very long time to even get to that stage of getting a permit to remove trees. As I mentioned before, we then had to have multiple challenges to even get our building permit by March 31st, 2016. We were under some financial pressure because no one would give us a construction loan until we had both the tree removal permit and the construction permit, building permit. We couldn't get a mortgage loan because we didn't have a structure. And so, quite honestly, that was the least of my concerns then. If you listen to the audio, I was very upset with the imposition of the fee. But I felt this was one of those cases where you pay the money now and you go back and seek a refund later with the proper arguments and with all the facts presented in the most comprehensive way.
And so in 17, when you came back with the enhancement, that was your intention?
To which?
To, at some point in the future, here's the enhancement that you did in 17. Was in 2017, again, your thought to look at getting the C of O and then
No, sir.
revisit it?
No, sir.
So up until you had your
Not
C of
until
O,
after we got the C of O and we were satisfied that the city was satisfied with what we had done and that we saw all that we had done and could take inventory on all that we had done, did we even start to think about the possibility of seeking a review of the entire matter. And I would point out, by the way, that this is, if you want to talk about ongoing process, if you really read the statute, we were still under supervision until April of 2019, because the statute says when there is mitigation, that the city arborist is to come back within 12 months to make certain that we've done what we said we were going to do.
so there is a time in that portion of the code.
That's in there. That code, yes, 12 months is in the code, as far as, when there's to come back and make sure that you properly maintain them, that they're all there, all that kind of thing.
12 months after when?
After the
COO?
certificate of occupancy, in this case. It says the order or permit, yes.
I'm sorry, Commissioner Shore.
You actually asked my question, which I thank you for that. But I'm somewhat curious why during all of this, did you not ever make the statement, or maybe you did, that you reserve the right to appeal at any time from the original 2015 decision?
In hindsight, I wish that I had.
I wish you had too.
In that moment, quite frankly, Commissioner Sharp, we had so many other things on our shoulders to try and move this project forward. And again, I would only say that, yes, that would be helpful in this case, but the fact is that the statute says you can file an appeal. It doesn't say when. And when there is an absence of time period, you have to read the statute as it is written. And then you can go, as Linda said, to issues of laches. And as I hope we have demonstrated in our filings and in our presentation today, there is not a case to be made for laches because there has been no prejudice.
One other point is that when we had the hearing, and my husband did try to ask for reconsideration, they started calculating the numbers and said that they were going to impose an even higher fee than the $13,000 that they had originally calculated.
Yeah, they went up to, they said, if you don't stop now, we're going to take you to 20,000. And you can listen to the audio.
It was punitive. It was definitely punitive and retaliatory in the way they were.
I think what I was looking for is just a straightforward answer to the question.
Sorry.
And I have that, so thank y'all very much.
I have a question of Mr. Mandelis, if I may.
He's gonna get a chance for
Okay,
rebuttal.
thank you.
So, I didn't know if any of the other commissioners had anything for the appellants.
Sorry, I have one more clarification. So you actually, because of the ambiguity, I think, I'm paraphrasing, so I mean what I think I heard. Because of the ambiguity of the code and the measurements based on the plan from which the mitigation fees were assessed, you felt that also you had to wait until you had implemented your plan before you had all the facts to file a complete appeal. Is that correct?
Yes.
Okay. Okay, thank you.
So 28:35, you were just under your 30-minute allotment. I'm going to turn it, Mr. I'm going to reset Mr. Mandalis. The floor is yours for rebuttal.
Thank you, Mr. Walton. Let me start with the Tommy Davis case that was raised, and that's goes right to Commissioner Sharp's question about paying under protest, and that's the one very distinguishing factor between that case and this is the very day, again, in that Tommy Davis case, what we heard is that it was paid under protest, and that's not an uncommon thing to do. You write on your check, paid under protest, and it reserves your spot in time in some ways. It didn't happen in this case. Mr. Bieber just testified to that. There was not paid under protest. In fact, it was paid then in 2017 because the decision had been made and that was the decision and they relied upon the decision. They asked for a modification of the decision in 2017. They didn't argue whether the decision was sustainable or not. So they asked for a modification and got it, and then they accepted a certificate of occupancy, and now there's an acknowledgement that there was nothing in the record that said they were paying under protest. There wasn't a letter that came with the check. There wasn't anything written on the check. There was not, I mean, there's just, the record is void of any protest to the payment. So reliance on the Tommy Davis case is just simply misplaced. Secondly, as to the fee in lieu of mitigation, to Commissioner Schlosser's point about do you have to have all the facts in place to be able to actually bring this appeal? There's two ways you can approach the Parks and Shade Tree Commission. One is appealing the decision of the arborist. In this case, the arborist said, you need to plant 90 trees or mitigate for 90, whatever determination she made. The second way you can get before the Parks and Shade Tree Commission is say, we agree with the arborist that that's the number of trees that need to be mitigated. We would like to pay a fee instead of mitigating those trees. So there was an opportunity here for the appellants to come before the Park and Shade Tree Commission and say, we're not asking for a fee in lieu of mitigation. We're asking to appeal the decision of the arborist. Had they done that, whatever the decision the Parks and Shade Tree Commission made about whether they could plant that number of trees, couldn't plant that number of trees, that decision would have been immediately appealable to you. But that's not what happened. There was a request for a fee in lieu of mitigation, and so we're here on that issue, the fee in lieu of mitigation. That will be the ultimate determination if you hear this on the merits. So this idea that you have to wait for the plan to actually be implemented to see if the fee was appropriate, if you're arguing about the decision the arborist made, that should have been the initial question before the Park and Shade Tree Commission, not a request for a fee in lieu of mitigation. So, look, appeals run from the time of the decision. That's just the way it works. Appeals don't ever happen after the fact. So imagine, you're probably more familiar with like a Board of Adjustment decision. So say that I go to the Board of Adjustment, I say I would like to build an addition, but I'd like it to go into the setback. And the Board of Adjustment says, nope, can't do that, can't build it into the setback. But I think they've wronged me. I think they got it wrong. Do I then have to go build my addition into the setback, get and do the plan before I can then appeal it? That's not the way it works. You appeal something from the date of the decision. So my point is, I feel like it's smoke and mirrors trying to move the date forward drastically, and you shouldn't buy it. There's a question raised as to why the statute is drafted the way it is. I'm not exactly sure why it's drafted that way. One thing I can explain that might inform your decision on this matter is that the appeals statute, section 253.20, is in Article 1 of this chapter of the code, chapter 253. Article 1 was established for, there was a Park and Shade Tree Commission established in Article 1. That commission under Article 1 was charged with looking at the city's parks, figuring out plantings that should go in the parks, looking at shade trees, should we have more shade trees in the parks? It wasn't until years later that Article 2 came, when Article 2 is the tree ordinance, which is what sets up all these caliper calculations and replacement trees and mitigation fees. So the Article 1 appeal statute was there for the very limited purposes of a body that really had not a lot of responsibility within the city. Then all of a sudden Article 2 came and set up this massive tree ordinance, and the Article 1 appeal statute didn't get changed. I don't know if it was an oversight, didn't get looked at, but that's the reason the Article 1 appeal statute reads the way it reads. It was never intended, at least when it was drafted, there was no thought put into the idea that this appeal statute might one day be relevant to a comprehensive tree ordinance. So but that's what we're left with. Finally, Mr. Bieber said you got to be able to rely upon the explicit wording in the city code. And he said that sound policy is that it should be heard. I also think that sound policy is that people should be able to say after 3.5 years, my property rights are defined. I know what my neighbor's doing and not doing. It's established. So under this explicit wording in the city code argument, it seems that appellate's position then is that because Section 25320 requires the appeals to be neither timely nor reasonable, the commissioners should allow an appeal to be untimely and unreasonable, right? Because the statute doesn't say it has to be timely, it doesn't say it has to be reasonable, then the reverse of that, which I think is the appellant's argument, is that you should allow us to be untimely, you should allow us to be unreasonable. And that's just simply a position you should reject. Thank you for your time.
We get our extra minute and a half.
Well, is there any further questions of Mr. Mandalis?
I just want to clarify. So you're saying that the appeal provision, I'm trying to think of the words you used. There was no thought given to the appeal provision, and especially in the context of the development of the second section that was developed after the first section.
I wasn't, so I became city solicitor very shortly after the tree ordinance was adopted, so I was not involved in the drafting effort. What I recall at least a couple times now is that when you look at Article 2, there was a time when we wondered how an appeal would be filed, if an appeal could be taken from the Parks and Shade Tree Commission. We looked through Article 2, didn't see an appeal section, and somebody said, and I don't remember even the context of where we were and what the group of people were, they said, but what about this provision in Article 1? And it doesn't say that appeal section is limited to Article 1, so therefore you got to presume it applies to the entire chapter. So I don't know that I can't say with certainty that there was no thought given to the appeals provision. All I know is that Article 2 was drafted and slapped onto that Article 1 of Chapter 253.
Thank you.
Any other questions?
Yeah, just a clarification, because it's a curiosity to me, and I think it may apply here. To clarify, when you discussed about the statement that was not used when the fee was paid,
paid under protest.
Stating that it was paid under protest.
Right.
Is that just a reasonable way to do it? Is there a legal precedent for doing that? Is it just a good idea to have done that?
There's certainly legal precedent. I don't have a case in front of me to give you that says, in this court said that if you paid under protest, it's going to mark your time. But it is commonly known and accepted practice to pay under protest.
But that doesn't negate one's right to protest.
No, I don't think so.
Legally.
I don't think so. So I just think that it is, as Mr. Bieber acknowledged, it would be a good fact for him to have in this case, because it is something that I think that possibly the
Understand
laches
that.
argument would go away.
I just want some clarification. Thank you.
Any other questions of the commissioners? It's 9 minutes, so 9 plus 14 is your time. It's the chair's call, but you really have 1 minute and 30 seconds, so I would be inclined to let you talk for 1 minute and 30 seconds if that's what you have left.
The Tommy Davis case, with respect to the issue of paying under protest, does not go to the issue of what the evidence must be presented to establish a defense of latches. So I just wanted to point out, I think that Mr. Mandalis is mixing apples with oranges there.
So
There are two different issues.
So in 1 minute left, here we go. Under protest, If you listen to the audio of the 2015, I clearly paid this under protest. The fact that I didn't write it on the check, I'm sorry I didn't write it on the check, but it was clearly under protest. The mayor was in that hearing, the city manager was in that meeting. I think they will both testify we paid it under protest, but we did what we had to do because we had to move forward. Mr. Mandela cites the Board of Adjustment practices. I would note that the Board of Adjustment has its own rules and rules specific with respect to the timing in which you take an appeal. So it's not a good thing to compare to this provision, which has no time provision whatsoever. The appeal is not with respect to the reasonableness of the mitigation fee. The appeal is that there should have never been the imposition of a mitigation fee, that we should have never gotten there because the law was misinterpreted, and we could, as the statute says, proven the viability of meeting mitigation on our own property. You only go to fees in lieu of mitigation when you're doing it, and you can't do it on your property.
I have one sentence to tie up. You're beyond your time.
We never said, and we would never suggest, that because the statute is absent in a time period, that therefore that means that you can be untimely and unreasonable. It's really very sad that Mr. Mandelis is characterizing our filing in that manner, and we implore each of you to please act justly and equitably in exercising your discretion to grant our appeal so that we can go forward with these very important issues.
That concludes all testimony, or all argument, excuse me, not testimony, argument, please excuse me. So then, Mr. Chair, it would be up to you to sort of set the stage and set it for deliberation.
Sure. You know, as Mr. Walton mentioned at the beginning of the meeting, this conversation or this appeal is based upon reasonable time. And it's not based upon the code. I know there are many flaws in the tree code, and I think that's why the city's giving serious consideration to all of this. And I think there is a flaw in the tree code from a timing perspective, because in 25320 it does not say specifics, whether it's 10 days or 30 days, as it does say in other parts of the city's code. You know, going back to the fee, I was at a few of those meetings, and the fees were a little bit over the top. And yes, I was at the meeting and heard you and the tone of your voice about the fee itself. However, then I look at, you know, going through all the dates and all the information that's been presented by Mr. Mandelis as well as by your side of the situation. And, you know, I'm looking at the 2015, 2017, 2018, and then 2019 when the appeal was actually filed. And from my perspective, right off the top, looks like it's an extended period of time. And I look at some of the questions that were asked before of Mr. Mandelis, and, you know, talked about how much in fees. I think the fees are much higher than $20,000 that have been collected since the tree code has been put into place. And I can recall at least two, and I think one of the ones that Mr. Mandelis mentioned, appeals to the Park and Shade Tree Committee that were filed in what I think was a timely fashion. I think they were within 10 to 30 days, both of those. I know there have been others, and I look to what you said about the Board of Adjustment. You're absolutely right. The Board of Adjustment has its own separate rules, but I think from my perspective as a commissioner, you know, I look at the city's code and I look at some of the things that I've seen from a judicial nature and seen that, you know, pretty much so across the board, most of the filings for appeals have been what I consider on a timely basis, which is a much shorter period of time than 3 years. Again, not to take away about the code itself, there are flaws, but that's not what we're deciding today, unfortunately. those things do need to be addressed and adjusted as we go forward. But from a timely perspective, I look at this and say, if we were to step forward and say that this was a reasonable time, I think all of a sudden that we would probably get many people saying the same thing, and until all infinitum. I mean, I could see some people actually coming back to us and saying, hey, that we were asked to take down our tree, or excuse me, we took down our tree, and one of these people next door wants to file an appeal to put it back somehow. And obviously, that's not going to happen. But I think the fact that we do allow any person to appeal is, and we've seen that in a couple of cases, that's kind of strange in my mind personally, because you hear from somebody across town saying what you can do in your own yard. And again, it comes back to the code flaws, and I'm sorry to get off track. But from a timing perspective, it just doesn't, yes, you paid under distress, if you can say that, but it wasn't, in my mind, said that this, I'm going to pay this, but I'm going to appeal this, or I'm paying under protest. This isn't the right thing to do. I'm paying because I want to get my building permit and go forward. And that's, you know, I guess, you know, where I come out is, yes, there are flaws, but it just seems, from my perspective, 3.5+ years seems to be a pretty substantial timing. And again, as I asked my question before about 2015 versus 2017 with an enhancement, there was no, that I can recall, any kind of language saying, hey, you know what, we've got an enhancement here, and by the way, while we're here, what you asked us to do in 2015 and we paid, we still think that's very wrong, and I just want to let you know that we're going to file an appeal once the process is done, once we have our C of O. So that's kind of the way I come out.
Well, I'll state my,
Sure, please.
my exact opposite reading of this, of Mayor, from your points, actually. I actually think it's wrong to start from the assumption that this is, this appeal should have been filed 3.5 years ago. I think, given the circumstances of this particular case, so much happened from 2015 when the original permits were filed and the initial fees were assessed, that would lead one to say, well, geez, things were changing so much, and at any point, really, you could have filed an appeal, and there seemed no end to kind of the back and forth on the permits and when they had to go in front of the commission, et cetera. So they started this in 2015, then had to go, is this correct? Well, can I ask them a question? Okay, so it's, I believe they went at least twice in front of the Parks and Shade Tree Commission, 2015 and 2017. And then in 2018, told to stop work, and they had to go correct some of their information. And then the code does specifically say that the arborist has to go back a year after their certificate of occupancy and review things. So I'm not sure how you could find an appeal, file an appeal, until you go through all those different, you know, parts of the process over the past 3, almost 4 years. I'm not sure how you could have the facts. I'm not sure how you could make a final assessment as to what the appeal would be, or even if you want to appeal, until you've gone through this whole process. And to include, so I look at the timing as really almost about a year, and not even, given that the certificate of occupancy was in 2018, so not even a year ago, I believe. And then there's another year that this is not going to come to closure, because the arborist has to make an assessment of whether or not you followed the plan. So in terms of timeliness, I don't believe, bottom line, that this was 3.5 years ago, that they should have filed it. I believe that things were changing over this 3.5 years to the point where where they had to wait to put in the appeal, just based on what I've heard from both parties. So that's my take on it. And then to underscore all that, the code it clearly doesn't say a time frame. I mean, so maybe you think 3.5 is too much, but is 2 years too long? Is 1 year too long? Is today too long or tomorrow? I mean, because we're still in this process for this particular property because the arborist hasn't made her final inspection. So that's my take, is it's not been 3.5 years. It's been a much shorter period of time. And quite frankly, I think there's still time given where the arborist is in this process. So that's my take on it. And I'm not making a final decision here on whether or not we should say yes or no or whatever to the actual ask. I'm saying, given these ambiguities, given the lack of a specific time frame cited in the code, given some of the evidence that I've heard here on maybe the timeliness is not 3.5 years, I actually think, given homeowners' rights and fairness, that at least give the benefit to the homeowner of having their day in court, as Mr. Mandela said, and we should have a hearing. That's where I stand on it at this point.
Just a process question. Is what you're looking for is a statement from each commissioner? Is that where we are at this point?
Well, if no one else has any kind of statement, then there would be a motion and a second to do something with the motion from the Park and Shade Tree Committee to allow the appeal from a reasonable time perspective, or not to allow the appeal. Motion to dismiss the appeal is really what the motion would be.
Okay. Just from everything I have heard, to me, it is clear-cut that the length of time is unreasonable, and the explicit wording that is lacking is reserving the right to appeal this at any time, especially if the initial decision by the Parks and Shade of the mitigation fee to begin with is where all the irritation and concern came from. That was known at the original decision. So that's where I am at the present time.
Well, yeah, I think it's just, to me, totally the opposite of being clear cut. I think it's very muddled. The whole thing is muddled to me and not clear because of these many different dates that have happened, because of the language of the code. I could state some of the same things that Commissioner Schlosser had said. And I know we're not debating the tree code, but it's hard to talk about and think about all this without realizing flawed and all the ambiguity that's in this whole process. I think it reflects fairly poorly on our city not getting on top of these things in a more timely way, if we're going to talk about the timeliness. So, but my sense on all of this, because it's not clear to me, is to give the benefit to the homeowner and to allow for an appeal. Now, I don't know where I would come out on a final decision. That's a different situation than what we're dealing with right at the moment.
Well, I'd have to say that, yes, the tree code is definitely flawed. I've been talking about this for a long time. I'm just very disappointed nothing's been done by now. But as far as where I stand on making this decision, the reasonable period of time is where I'm stuck. And I wish I wasn't, because I feel for you. I feel that the amount of money that was assessed was way over the top. But at the same time, I'm not willing to open up the gate to anyone who wants to appeal when there's been, okay, 3.5 years, maybe it's not 3.5 years, maybe it's only a year, but almost everything in our code is in the matter of days. So I just feel that I wish you had been able, a year prior, to have come to us. It would have been a different story. So that's where I stand.
Yeah, I agree with the way that Commissioner Burns kind of introduced his comments, is that things are, we live in the shades of gray and very few things are binary in life and in the things that happen in our municipality. But I just tried to put myself, reading this language and what I would have expected of me as a non-lawyer, and I would have expected me to make it very clear that while I was doing some of the things that you did, which was to do what I had to do to kind of get the process, keep the process moving based on all of the moving targets that were present at the time, I would have liked to think that I would have said, I'm doing this for this reason, but I am unhappy with this. I fully expect to exercise my rights to dispute this and to file an appeal. And I would have worked with the Park and Shade Tree Commission. I would have worked with the city arborist to say, okay, now what's the timing of this? Because I'm definitely going to appeal this. I would have known then that I was going to appeal it, because I would have been very unhappy to have spent money that way. And so while the merits of all of the things that have transpired since 2015 and maybe before are valid, I can't help but to apply what I think is a reasonableness approach to this, and the fact that there wasn't any real documented evidence that this was going to be appealed, and then to seek when would be the right time to appeal it is difficult for me to overcome. And so I believe, as complicated as all of these facts together are, I would have wanted to be very vocal about my intent to appeal.
Anybody else? If not, I'd like to have a motion and a second on the motion to dismiss. Is that?
Motion should be stated in the affirmative. I make a motion to grant the motion to dismiss presented to us. If you vote yes, that means the appeal would be dismissed. If you vote no, you oppose it and you want to hear the matter on the merits.
I can't do that, right?
Yeah,
I make a motion to dismiss
grant the motion to dismiss.
to grant the motion to dismiss. Thank you.
Second.
We have a motion and a second to grant the motion by the Park and Shade Tree Committee to dismiss the above referenced appeal of Sander Bieber and Linda Rosenzweig for 103 Lake Drive. I'll just go down by Commissioner Sheffer,
Aye.
Commissioner Kaluzzi,
Aye.
Commissioner Schlosser,
No, for the reasons I stated earlier.
Commissioner Sharp,
Aye.
Commissioner Byrne.
No, for the reasons I stated earlier, and I'm certainly not interested in opening the floodgates for anyone and everyone to come and appeal. My comments, my vote are very specific to this very specific situation that's been in front of us right now. Again, I give the benefit because of a lot of ambiguity and to the homeowner, and my interest in the ability in this specific situation to appeal.
All right, thank you. And, you know, from my perspective, this is one of the hardest decisions I've had to make, being either a commissioner or the mayor, because it just does show the flaws in our code, and it is kind of an embarrassment from a city perspective that This has been sitting in here for so long, and it goes back years and years. But I would have to vote aye on this to grant the motion to dismiss.
With that said, Mr. Mayor and Commissioners, what I would propose is that we'll get together and we'll prepare a written decision, much shorter than the last time, when we had one of these appeals, and we'll get that to you, and then we'll get that approved. And when the written decision is issued, that will be the final decision.
If there's nothing else, this meeting is adjourned.